Hey, in the case we're reviewing today, we note that it is printed at the back portion of a lotto ticket, specifically for Lotto 642, which is the subject matter of this decision, that prizes will not be paid if the ticket is altered, defaced, torn, damaged, or has failed any of the validation tests by PCSO. But we ask, why did the Supreme Court order the PCSO to pay Mendoza, the 2014 642 lotto winner, despite his partially blackened ticket where only two digits of the three bet combinations were visible? Before we answer this question, we'd like to tell you about Usana's Saliviv Hydrating Eye Essence. Lessen the look of dark circles and puffiness with Saliviv Hydrating Eye Essence. Check out this product in the link found in the description of this video. Now, let's go back to the case with its facts. Mendoza won one of the lucky pick number combinations he had bet on. Unfortunately, his granddaughter grabbed and crumpled it, and in an attempt to straighten it out again, his daughter ironed the ticket with a piece of cloth covering it. This resulted in a blackened ticket with only the first two digits of the three bet combinations remaining visible, the outlet from which he bought it, the draw date, the date of its purchase, and partially the time it was purchased. Later, the Sweepstakes office declared that they would not pay the prize for two reasons. Number one, in accordance with its no ticket, no payment policy, and number two, because when Mendoza purchased the lotto ticket, he agreed to the rule, along with the other rules printed at the back portion of such ticket, that the prize will not be paid if the ticket is altered, defaced, torn, damaged, or has failed any of the validation tests by PCSO. Are the rules of the PCSO so clear that they leave the reader no room for other interpretations? No. The court said that the rules are actually ambiguous and susceptible to interpretation, so much so that while PCSO insisted that the presentation of the complete physical ticket is a condition precedent before their duty to pay the prize money arises, Mendoza and the Committee on Games considered the selection of the winning combination as the essential condition precedent. The court noted that even the PCSO rules has no reference to a winning ticket. At most, a ticket was only defined as produced by a terminal confirming the selection made by the customer, meaning the ticket is only proof of the fact that the bettor selected the winning combination of numbers. Therefore, said the court, it is the act of selecting the winning combination that entitles a bettor to the corresponding prize. So, did Mendoza sufficiently prove that he actually selected the winning combination? Yes, he overcame the burden of proof through a preponderance of evidence. Number one, no one besides him sought the lotto jackpot prize for the date he won. Number two, during the hearing before the House of Representatives Committee on Games, the lotto terminal operator testified that Mendoza is her regular customer. Number three, the NBI cleared Mendoza and his family members of deception after conducting polygraph examinations and checking that they have no derogatory records. And number four, PCSO admitted that Mendoza's ticket was a genuine and authentic PCSO generated ticket. The sweepstakes office also intended to draw an analogy with the 1992 infamous case of the number fever promotion, where an unusual number of winners claimed to have won the jackpot prize for the 349 crown. In that case, the court dismissed the specific performance cases filed against Pepsi Inc. for the claimant's failure to comply with the conditions precedent for winning the prize. Is the sweepstakes office correct in the assertion that the conditions precedent for the payment of the jackpot prize in this case with Mendoza is the same as the number fever case? No, the court said that they are actually different. In the number fever case, the elements of a winning crown had been predetermined and enumerated, even in the campaign posters of the game, which include not only the three winning number combinations, 349 in that case, but also a seven-digit alphanumeric security code. Unfortunately for other 349 crown holders, they had a different alphanumeric security code, so they could not win the prize. Compared to the present case, the only condition was for the numbers that a person betted on be subsequently drawn for the 642 lotto. That condition was completely satisfied by Mendoza. Other significant questions that we can answer from this case. Letter A. Why did the court just adopt the findings of the RTC, or Regional Trial Court, and the Court of Appeals on whether Mendoza actually selected the winning combination? Answer: because the petition before it is a petition for review on certiorari under Rule 45, which, per said rule, only admits questions of law primarily and not of fact, unless exceptions are present in the case. Letter B. It will be noted that the lower courts gave merits to the secondary evidence presented by Mendoza instead of applying the best evidence rule. Why was it not necessary to apply the best evidence rule, which requires the production of original documents to be presented instead of testimonial or secondary evidence? Answer: Number one, because the best evidence rule applies only where the content of the document is the subject of the inquiry. Where the issue is the execution or the existence of the document or the circumstance surrounding its execution, the best evidence rule does not apply and testimonial evidence is admissible. In the present case, it is actually the existence of the ticket that was being assailed by the Sweepstakes office. Hence, the best evidence rule does not apply. And number two, because even under Rule 130 of the Rules of Court, secondary evidence is resorted to when the original document is unavailable. In this case, aside from the Sweepstakes office not questioning the content of the winning ticket held by Mendoza, Mendoza seems to find it unnecessary to officially present the winning ticket as evidence because the full contents therein are not any more visible anyway. Proving its existence and the fact that he has the winning numbers through secondary and testimonial evidence were the better way to go.